So today we're going to be starting with something a little bit off season because someone made a comment on my post that was quite unrelated to the subject. Someone from the writer movement actually asked a question which I would love to attend to. And the person said, please, your thought on VDM and Blord issue, don't be quiet about it. Remember, you posted when Blord seemed to have the upper hand. And so, what if I told you this might actually backfire on VDM? Some of you instantly start shouting you are a hater, but wait, let us talk first because before you jump into the name calling, facts are not biased. We've heard of three words in this conversation. We've heard something like acceptance letter, trademark approved, it now belongs to VDM. But hold on, an acceptance letter is not ownership. It simply means that the registry has reviewed VDM's application, and at that point, there seems not to be any immediate conflict. So, this does not mean VDM has a certificate, it doesn't have the final registration, neither does it have exclusive legal control. So basically, what it means is that VDM has passed the first stage and now can proceed to publication. And here is the part that many of us might not be aware of. After acceptance, the trademark gets published in the Nigerian Trademarks Journal. And once published, there is a 2-month opposition window. 2 months. That means anyone who believes they have prior rights can challenge. They can challenge it legally, formally, or officially. And this is where things get interesting because in trademark law, prior use is very powerful. That is to say, if I've used this name in my business, if I've used it in my transactions, if I've used it for goodwill, if I've used it even for branding or reputation, that matters, it counts. So even if the person never registered the trademark, Nigeria recognizes something called passing off. This protects businesses that build reputation under a name. So VDM registration is not the only weapon. He has to prove the use, the recognition, and most importantly, the goodwill. Those two count. So let's talk about the strategy because this is where emotions can mislead people. Because from the legal strategy perspective, making loud declarations like we've heard VDM say like, I'll sue you, I'll get you arrested, it belongs to me now, before full registration, that can become a problem. Why? Because the court looks at behavior. Court also looks at the intent, the conduct, and the good faith. So if it appears an application was filed not to build a brand, but to intimidate or to retaliate, that can weaken the case too. So if VDM had waited quietly, allowed publication, obtained the certificate, and then spoke, that would have been a solid legal position. But announcing dominance too early, this gives Blord room to argue that this might be bad faith, it could be harassment, and could be bullying. So if Blord opposes, he can argue, I've been using this name for years, I have built business under this name, there is a market recognition, there is goodwill, and that becomes a serious legal debate. So the bottom line of this conversation is that an acceptance letter is not final registration. It simply means the registry has done an initial review. The mark can now be published, and then third parties can now oppose. So Blord can now oppose it. Anybody can oppose it. So as at the time of this conflict being around February 23rd, VDM claimed he made his filing in January 22nd, thereabout, and the publication likely might not even have happened till even now. So the opposition window is likely not even open or at open. And so within this time, Blord can actually argue or take this legally. So with just acceptance letter, he has no enforcement right. He has no right to sue for infringement or stop anyone from using the name. Threats like that can actually weaken his argument if Blord decides to file or oppose this in courts. So it is a truth at a time. Take care and have a nice day.